Thank you very much, Your Excellency. Now we get to our first panel discussion of the morning. This is going to be about balancing justice, complementary systems, or competing paths. The moderator for this is going to be Sylvia Nouri. She's a partner and global head of Africa Disputes Group at Freshfields, and she's joined by a group of esteemed panelists, including Sir William Blair, the former judge in charge of the Commercial Court of England and Wales, Chief Justice Wayne Martin at the DIFC Courts, Brigid McCormack, the President and CEO of AAA-ICDR, Christy Tan, the Judicial Commissioner of the Supreme Court of Singapore, and Professor Jan Paulsen, President, SCCA Court, President of the Bahrain International Commercial Court. Please give them a warm welcome as well.
Good morning. It's a real privilege to be kicking off the first panel discussion today with a suitably ambitious topic, balancing justice, in which our very distinguished panelists will survey the various dispute resolution systems available across key jurisdictions, including the conventional courts, the newer international commercial courts, international arbitration, and mediation. We will discuss whether these are distinct parallel systems that complement each other, or whether they compete with the potential to cannibalize each other. We'll also engage in some crystal ball gazing and consideration of what a utopian dispute resolution ecosystem might look like. Which aspects of the systems available today would it adopt? We're truly privileged to have as speakers on this panel this morning several very senior leaders from all the dispute resolution systems I have just mentioned. After our speakers have shared their perspectives on this topic, we'll open the floor to questions from the audience. So without further ado, I'd like to kick off our discussion this morning with some insights on the new wave of international commercial courts. Now, 9 of these courts have been established in the last decade alone, including 2 here in the Gulf, in Abu Dhabi and most recently in Bahrain, although the DIFC courts and the Qatar International Courts have of course been around for longer. These courts are not homogeneous. They have their differences. And while time will not permit us to compare and contrast all the international courts that have sprung up over the last 2 decades, I will turn first to the Chief Justice of the DIFC Courts, now celebrating their 20th anniversary, for his perspective. Wayne, what aspects notably differentiate the DIFC courts from other justice systems, including conventional courts and arbitral tribunals?
Well, thanks very much, Sylvia. In addition to the 4 courts in the Gulf region that you've mentioned, the new wave of international courts includes courts in other parts of the world, including a court in Kazakhstan, a court in Singapore, courts in Shenzhen and Xi'an in China, and English language courts in France, Holland, and Germany. All the courts have differences. They come in different shapes and sizes, and that, I think, is to be very much welcomed. The major points of difference relate to things like whether they have a geographical jurisdiction. So the courts in Dubai and Abu Dhabi each have a geographical jurisdiction. In the case of Dubai, it's about 100 hectares in the business district of Dubai, and entities that are registered to carry on business within that district are automatically within the jurisdiction of the court, and a similar approach is taken in Abu Dhabi. Those courts that have geographical regions also have their own legal systems, so that in the case of, again, Dubai and Abu Dhabi, there are commercial laws that operate within the geographical area that those courts cover. They're separate commercial laws, so they are commercial laws that are quite separate and distinct from the commercial laws of the UAE. In relation to those courts, there are also provisions for default laws that differ, so that in the case of a legal lacuna in ADGM, the gap is filled by the common law of England and Wales. By contrast, in the DIFC, Any lacuna is filled by the common law of the DIFC, which is being developed by the courts of the DIFC. Courts have different arrangements in relation to jurisdiction, so that there are some courts, including DIFC Court, has what I would call an opt-in jurisdiction, which merely requires an agreement between the parties and the court automatically has jurisdiction. Courts differ as to whether they are part of the domestic courts or entirely separate courts. They differ also in relation to procedure, whether they have civil procedures, common law procedures, or a hybrid. They differ in their emphasis on mediation. Some courts in some divisions mandate mediation, others proactively encourage, others are not quite so proactive. They differ to the degree of digitalisation. Most of courts offer online filing, most offer virtual hearings, but they differ in terms of the extent to which they also offer in-person hearings. They differ in relation to language. Some courts operate exclusively in English, others offer the local language as an option as well, and they differ in terms of enforcement. So that in the Dubai courts, the DIFC judgments are enforceable throughout the Emirate of Dubai by the Dubai onshore courts and also throughout all of the Emirates of the UAE. So there are lots of differences between the courts in various different respects. The French have a saying, vive la différence, and I think that applies very well to the international courts. Differences don't mean that one is better, it means just that they're different, and it provides a greater range of choice for potential litigants, and it also means the court can benefit from learning from each other and improve the services we offer to the parties. Thanks.
Thank you. To get a perspective from Singapore, Christy, the Singapore International Commercial Court has now been around for a decade. What characteristics of particular note do you bring from your jurisdiction?
Thank you, Sylvia, for the question. I would first like to thank the organizers of the SECA for the opportunity to participate in this conference and to be on this panel discussion. What I propose to do is, given the limited time, to highlight key features of the SICC that would be of particular interest to a litigant as it navigates a court case from start to end. And I will then close with some observations on how the SICC compares as against, say, arbitration and our domestic courts. So jurisdiction, which is what I begin with, the SICC is a division of the General Division of the High Court of Singapore, so it is considered a Singapore court. And it has jurisdiction in three main areas. First, jurisdiction over international and commercial disputes where the parties have chosen the SICC as its forum. Second, a supervisory role over international arbitrations which are seated in Singapore. And third, an area which we are developing, jurisdiction over corporate insolvency and restructuring matters that are international and commercial. So to a litigant, I think the next point of interest would be who's going to hear the case. And I turn then to the judges of the SICC. The bench comprises a standing panel of international and domestic commercial judges, the international judges being very distinguished arbitrators or retired judges drawn from the common law and civil law countries, which ensures the availability of adjudication experience and expertise in different legal traditions. Then legal representation, which is also important to litigants. Will they have counsel of choice? And in this regard, registered foreign lawyers may represent a party in an offshore case, meaning an action with no substantial connection to Singapore, or with the court's permission in corporate insolvency and restructuring cases. And there is also the possibility of the court ordering a question of foreign law to be determined by legal submission instead of having to prove it by way of expert evidence. And in those instances, registered lawyers can also appear to make the legal submissions in the way you would in, let's say, arbitration. Of interest would be how the case is going to be conducted. And in this regard, there are three adjudication tracks that the SICC offers. A pleadings track, which would be quite familiar to those in arbitration. You exchange pleadings, followed laterally by your witness statements. A statements track, which is for cases where there are very few or no factual disputes, and therefore the case can be decided on the basis of just statements. And the memorials track, which would also be familiar in arbitration circles, where you have a compendious memorial being exchanged. In terms of case management, as the case proceeds and works its way through the courts, case management is active, early, and judge-led. So this means a docketed judge hears the matter at an early stage and at regular intervals to check in on progress, and the court may also give directions to facilitate amicable dispute resolution. Finally, when the case comes to an end, there is an appeal mechanism. So appeals from first instance decisions may be brought to the Singapore Court of Appeal, where you will have at least one international judge empaneled as part of that Court of Appeal quorum hearing the appellate case. And there will be the usual practice is for the SICC as well as the Court of Appeal to publish judgments of their decisions. So there is going to be transparency in terms of the decisions made. Finally, at the end of the case, legal costs, of course, are very important to litigants. The cost regime in the SICC is commercial-centric, and what that means is that the court inquires into the costs actually incurred by the parties, by the successful party, and the costs recoverable will be to the extent they were reasonable and proportionate. So it's an approach that hews closer to arbitration and is distinct from the approach which is applied in the General Division of the High Court, where because of excess of justice concerns for litigants, the level of recoverable costs is determined by an objective standard and with reference to existing cost guidelines. And third-party funding is also allowed for proceedings commenced in the SICC. So if I pull back just a little bit from what I've described in terms of the features of the SICC and just make some high-level observations, I think it would be fair to say that the SICC combines the advantages of arbitration, such as a wider range of choice of legal counsel, flexibility in the adjudication tracks, as well as a more generous cost regime and availability of third-party funding, with the traditional advantages of litigation, such as adjudicators who are a known quality and of an established quality, case management powers to facilitate alternative dispute resolution, transparency of decision-making, and the availability of an appeal. So this manner of structuring the SICC, its procedures, its approaches, is very much by design, and it reflects a commitment on the part of the institution to being innovative, flexible, and focused on effective and efficient administration of justice, all for the benefit of international commercial disputants.
Thank you, Christy. It would seem to some extent the international commercial courts cherry-pick the best features of both international arbitration and the conventional court. So I'd be interested, Bill, as a former president of perhaps the most well-established conventional commercial court in London, do you think the proliferation of international commercial courts over the last 2 decades has dented the popularity of the London court and other conventional courts like it?
Well, thank you very much, Sylvia, and I thank SCCA for the very kind invitation to speak this morning. It's not just a privilege to be here, but it's an honor to be here at a time when Saudi Arabia is assuming such an important place in global affairs. So, as you say, the London Commercial Court is well established. It's one which attracts a preponderance of international cases. So, in that respect, it's an international commercial court and perhaps the very first. The judges are drawn from the national judiciary. And let me just say a word about that. We've heard about panels of judges who are drawn from different jurisdictions. And the same, incidentally, applies to the Qatar International Court, where I sit. We have judges, again, drawn from all over the world, and of course, and most importantly, from Qatar itself. And I think that is the biggest distinction between international commercial courts and what you've described, Sylvia, as traditional commercial courts. But here's a point that I think is important. Most countries will continue to do the same as we do in London, including those which have recently reformed their commercial courts to make them more attractive internationally. So I give the example of France, I give the example of Germany that Chief Justice Wayne mentioned, which is about to introduce reforms that take effect in a few weeks' time. It's the same in China with the International Commercial Court, and it's the same in Saudi Arabia, where there have been important reforms to the Kingdom's commercial courts recently. I don't think there's any single model. I think states that want to reform their commercial courts, and we've heard the reasons for that this morning, to provide a solid judicial basis, should look to adopt the model that best suits their particular needs. Now, you asked me to mention a couple of things that we have done in England that may be of interest. The first is something that is very common in international arbitration as well. We're looking very closely at our procedures to see where they are succeeding and where they're not succeeding. And I think that's something that we all need to do. But the other thing I want to highlight is how we as a commercial court relate to arbitration and mediation, and how commercial courts work with each other. And here I thank Audley Shepherd of ICCA for his contribution to our work in that regard. So the Standing International Forum of Commercial Courts now stands at over 50 jurisdictions, including the KSA. At our 2024 meeting, senior Saudi judges, including from the Riyadh Commercial Court, made a presentation on AI. Now, you raised finally the question whether this constitutes competition that I think, as you put it, may have dented the workload of the London Commercial Court. We don't see that. The workload remains steady, and more importantly, I think, the number of these cases and the role of law in deciding these cases is only going to increase.
Thank you, Bill. I think it's time for a perspective from the world of arbitration. So, Brigid, from your vantage point at the head of the American Arbitration Association, do you think these international commercial courts have the potential to cannibalize international arbitration, given some of the advantages that we've heard?
Well, first of all, thanks for including me as well in this important conversation, and having that conversation here seems extremely fitting, and I'm honored to be here. The AAA and the ICDR, our international dispute resolution business, are honored to be connected with the SCCA from its inception. I'm of the view that more options for resolving disputes is better for the dispute resolution ecosystem generally. That more options for users means better outcomes for users, and you have the opportunity to fit the forum to the fuss. And some forums are better for some fusses than others, and arbitration will continue to be better suited for some fusses for reasons which probably most people here are familiar, but are still important. First, among those, probably global enforceability, but a close second, confidentiality and privacy. There are going to be parties that are concerned about trade secrets or reputational risk or other sensitive issues that are going to prefer arbitration's confidentiality. The autonomy and flexibility that arbitration offers parties. Parties can select arbitrators with deep industry expertise, craft procedures that fit the particular dispute best. And for many parties, the neutrality and avoidance of a home court advantage is going to attract them to arbitration. And finally, finality and efficiency continue to be strong arguments for many disputes. Again, not all disputes. I'll go back to my opening point. I believe arbitration and international commercial courts are both elements of a healthy dispute ecosystem, a healthy dispute environment. And the more they collaborate and support one another, the better it will be for users.
So enforceability and the New York Convention are often described as one of the biggest advantages of arbitration. Wayne, I believe in the DIFC Courts, you've adopted a novel tool to enhance enforceability of judgments by turning them into arbitral awards?
Well, there was an attempt by Chief Justice Wang, who is, of course, a very experienced, former Chief Justice Wang, a very experienced arbitrator, to try and get the advantages of the New York Convention for judgments of the court. And of course, judgments of courts generally are much less enforceable than international arbitral awards. And so a practice direction was issued in 2015 under which when a payment dispute arose, that is to say a judgment of the court was going unsatisfied, parties were encouraged to enter into an arbitration agreement to be managed, the arbitration to be managed by the Dubai International Arbitration Centre, so that then that payment dispute could become the subject of an international arbitration award and enforced in any of the countries that are party to the New York Convention. It hasn't really worked, to be brutally frank. The problem, I think, is that unless parties enter into such an arbitration agreement before the judgment of the court is entered, it's very unlikely that they'll do so after the judgment of the court has been entered, because the judgment debtor is unlikely to voluntarily surrender to enforceability in all the countries that are party to the New York Convention. So it hasn't really worked, to be brutally frank. It might work if parties are prepared to enter into an agreement before the judgment's entered, but it just hasn't received the takeoff that might have been hoped.
An example of complementary systems perhaps not working exactly as one would hope. Jan, as someone who sits as an arbitrator on arbitral institutions, including presiding over the SCCA court, as well as one of the international commercial courts presiding over the newest court in Bahrain, it would be interesting to hear your perspective on the key comparative benefits of these systems and whether they compete or complement each other.
Thank you very much, and good morning. It's nice to be with you all. It's still the morning. I have been asked to address the subject from the perspective of my position as president of the Bahrain International Commercial Court. I think it's, before we start talking about the proliferation of international commercial courts, it's important to recognize that these courts aren't all alike and that their differences may be very important indeed. So let me, it's not very complicated, but there's some detail in it and we need to keep track of what's what. Let me give you this example. Having been outside the country for quite some time, I returned to Bahrain about 5 years ago and discovered something astonishing. I say that so that you're clear, I had nothing to do with it. In Bahrain, the country had decided that given that so many contracts in Bahrain are signed in the English language, to become a bilingual jurisdiction. That means that any contract signed in the English language, including between two Bahraini parties, will be heard in English. If there's a dispute, it will be heard in English. If it goes up to the Court of Cassation, which is the highest court, it will be heard in English. Now, I can add, Bahrain has the interesting particularity that 3-member panels can include an expert. It has to have 2 judges, but can include an expert. An interesting concept. There's no reason why that expert couldn't be a foreigner who is an expert in a foreign law. And so you see on the Bahraini Court of Cassation 2 titular judges, and I think maybe in this room there may be a couple of Englishmen who have sat on the Bahraini Court of Cassation as experts, deciding as one of 3. Is that an international court? It's a national court of the Kingdom of Bahrain. Now, so how are we to understand the idea of an international court? Is it an international court like the International Court of Justice, created by the United Nations? No, it's not a creation of an international organization. It's created by a nation state. So what are the possibilities here? Nation states can stake out their own positions. I'm originally Swedish, so I take this example, and I hope it's still true. I have never practiced in that country, but 2 non-Swedish parties who for some reason think Sweden is a nice neutral country and they have intelligent people there who might make good judges, and therefore their case should be heard in Sweden. No, there's no jurisdiction because there's no connection with Sweden. Swedish judges are paid for by the Swedish taxpayers, not foreigners. Well, that's wrong thinking. Other countries, like England, have discovered the idea of invisible exports. It's very good if two foreigners come to your country and litigate in your courts. It's good for the airlines, it's good for the hotels, it's good for the lawyers, and so it can be. And you're opening up the national courts to the local courts of your country. It can be done not in the United States, in New York. I think the center of New York as an international banking hub has something to do with that. So, yes, that sounds like an international commercial court, but you will find no foreigners from the forum on those courts. So, if you have parties from different jurisdictions, from different continents, they don't see their own faces on those courts, or they might not have the same feeling as a court which has an international composition. Then came the first movement to something surprising, which was the brainchild of the Chief Justice of Singapore, Sundaresh Menon, who 12 years ago really got into thinking about Singapore creating the Singapore International Commercial Court. He was kind enough to ask me to be part of a group of internationally active people who studied what then became the Singapore International Commercial Court. And I hurry to state that Chief Justice of Singapore has never sat on that court, and I have never sat on that court, so we weren't creating a court which would be particularly nice for us. That court has been a success, and Bahrain has observed that court. And so Bahrain today has created the Bahrain International Commercial Court, which the first collection of judges, coterie of judges, I might say, was promulgated by a decree of King Hamad just a few weeks ago. So it's brand new, and it's a creation of the national legal system, but it has a majority, a large majority of non-Bahraini lawyers. If I take it geographically, from the west, Sir Christopher Greenwood, and all the way over to the east in Korea is the great Dr. Shen sitting on that court. So that, in terms of the taxonomy, I think is an important thing to keep in mind. What happens to the decisions of those courts? 2 points. They can be appealed because these are national courts. And what happens then? They go to the Supreme Court. In Bahrain, that would be the Court of Cassation. And here again, it's important. The first reform in Bahrain I told you about, it's a bilingual jurisdiction. If the judgment of the Bahraini International Commercial Court comes down in English, it will be heard, even if there's an appeal at the Court of Cassation in English. Very likely that one of the judges will be an expert who knows something about the law that was applied, which may be the law of Bahrain. One final point. Difference with Singapore. Bahrain is a civil law jurisdiction. The applicable law for basic commercial questions is the civil code. Civil code in Bahrain looks very much like a code I'm quite familiar with, which is the Civil Code of France, which came to Egypt under Napoleon 250 years ago, and was then revitalized in Egypt by the great Sanhuri. So I tend to think of the codes that we see in the Gulf as the versions of the Sanhuri code. Not in French anymore, it's in English and in Arabic, and that's what's applicable. So you see that there's a range of things that you can mean when you're saying internationalization, and depending on what parts of it you like, you may be more or less or passionately attracted to it.
Thank you, Jan. So looking into the future now, while the consensus seems to be that the various courts and arbitral systems can complement each other, when each has the aim of growing its share of disputes, some competition is surely inevitable. So gazing into your crystal balls, what do you think will give a particular court or arbitral institution the edge over the next 2 decades? And I'll start with Bridget with that question.
And again, my overarching premise is there's a lot more pie to bake, and I believe that even in the future, there will be more disputes that need more dispute resolution options. But having said that, each system is going to have to be able to adapt to the disruption that technology and generative AI technology in particular is presenting to the buying and selling of legal services. the operating systems of dispute resolution are going to have to keep up with the market, the buying and selling of legal services market. And so AI native case management system and point solutions will soon automate administrative tasks. AI-assisted legal research is going to enhance consistency and predictability of decisions. Predictive analytics are going to help parties assess outcomes before filing, probably influencing forum selection. And the institutions, arbitral or courts, that can embrace what that technology means for its processes, its services, might attract more and more cases due to the speed and cost efficiency that those options will provide. In addition to that, fully online dispute resolution processes, start to finish ODR, is going to be a choice that makes sense for certain disputes and for certain parties. And so institutions that can offer that will be a good option for those parties. And similarly, there will be certain disputes and certain parties who will be interested in blockchain-based dispute resolution. And again, the institutions and courts that can offer those solutions will have some advantage for those parties in selecting a forum.
And so we saw this morning how important digitalization is here in Saudi. Our panel was discussing whether any of the courts globally have the edge right now in terms of technology. And Bill, given your place on the Standing International Forum of Commercial Courts and the best practices you're sharing, I wonder whether you have a view on how the courts are doing in terms of getting ahead in technology or AI.
Well, I think you're asking is one system or another going to get ahead, and is AI going to make a difference to this? And I think it's a really important question. But just before I address that, I want to pick up something that Jan said, because I think it is correct. One of the tests of whether you're reforming your commercial courts, for example, the tests they've just applied in Germany, in the reforms that are about to take place, is the use of the English language and enabling parties to do cases in the English language. But I do agree with you that there are, in fact, a range of things that entitle you to use the word international. So, Sylvia, coming to your question, could one particular group or type of court pull ahead, or could arbitration pull ahead, or is there going to be a pulling ahead? I think that could happen, and I think it could happen for the reason that's already been given, that technology, particularly AI, is going to make a big difference. I think we all agree it's going to make a big difference, but we don't yet know what that difference is going to be, and we can't really predict right now as to whether one form of dispute resolution is going to pull ahead. But let me suggest three things that are going to decide this. And the first is who commits and invests in technology and who doesn't. And let me now move to part of the world that we haven't really discussed yet, but it's important in this debate, and that's China. So China now has targets, a 2030 target for the use of AI in both courts and arbitration. That's a matter of state policy. And really, I think it remains to be seen how far others are able to keep up with that. And that's the first point. The second is to agility. I mean, what I mean by that is the ability of courts and arbitral institutions in adapting their rules and procedures, and I agree with what you were saying about the depth of the change that there could be. But the third and most crucial point is really the trust point, which was raised various times this morning. Unless these new technologies gain trust, they won't gain traction. Now, just one addition to that, though, we shouldn't just be thinking in terms of technology, because however good the technology is, it's not going to displace the need for humans having the preeminent part in deciding issues which need to be decided. And by the way, I would include things like procedural hearings, which are often used as an example as to how AI may help. So that's quite a complicated answer to what was put as a simple question, but I'm not sure how simple it turns out to be.
Wasn't intended as a simple question. Thank you, Bill. Now, if you had carte blanche and billions of dollars to build a disputes ecosystem from scratch, a mandate from the Ministry of Justice of Utopia, how would you build it? And I'm going to ask Christy that question first.
So, thank you, Sylvia. And I understand you to mean an international commercial disputes resolution system, because obviously the domestic dispute resolution systems, the needs of that may vary across different jurisdictions, and it also implicates issues such as the common man's access to justice, which is not really the focus of today's panel discussion. So if we're speaking about an ideal international commercial disputes resolution system, I would begin with the institutions that I think should be in place. And I think there are three institutions that would really be the pillars of the system. The courts, obviously, and second of all, a strong arbitration institution or center. And third, I would also suggest a strong mediation institution or center. The court system would comprise a domestic court with experienced judges to hear cases on the specialized commercial cases list, as well as an international commercial court. And I would have both courts be complementary in the sense that it's about giving users the options. So for example, in the Singapore context, cases can actually be transferred between the SICC and the General Division of the High Court, and complementary also in the sense of leveraging off each court's best practices, knowledge management, technology, as well as processes. The courts, I suggest, should also be comfortable with applying foreign law, and the legal system should apply a robust set of conflict of laws principles. And that's because the reality is that cross-border disputes frequently raise at least some points of foreign law and also questions as to which laws to apply to a given issue. I suggest that the courts should also be given the powers to make orders that are frequently required in international commercial disputes, such as orders for interim injunctive relief, anti-suit relief. And where the court is the seat court for international arbitration proceedings, it should take a pro-arbitration approach, which means minimal curial intervention, but of course not shying away from exercising the supervisory role where required to protect the integrity of the arbitral process. Turning to the arbitration institution, it should have a comprehensive set of up-to-date arbitral rules and a well-organized registry with legally trained personnel to ensure effective case management. For the mediation institution, I would say that that should be active in exploring innovative approaches to alternative and appropriate dispute resolution, and also play a role in training and accrediting mediators to ensure a quality pool of mediators. And most importantly, the three institutions, the courts, the arbitration center, the mediation center, they should cooperate and speak to each other. So for instance, institutionalizing means for identifying and referring opportunities for mediation in the course of dispute proceedings, be it in arbitration or be it in litigation, and providing institutionalizing means for recording settlements as arbitration awards or as court judgments to bolster their enforceability. So it's all about ensuring a suite of interoperable options for the parties. And I think the final point is that beyond setting up the institutions and defining their roles and powers, I would also people the organizations with forward-looking individuals, because it's really the people who drive the organizations, a point that I think Bill alluded to. So these individuals, they will need to continue to explore innovative approaches. For example, how AI, as Bridget mentioned, can be increasingly and responsibly deployed in parts of the adjudication process. To explore that, to explore, for instance, how different kinds of adjudication may actually be made available for different parts of disputes. Innovative things like that, you need the people behind the institutions to drive. So if I had carte blanche, that is what I would do.
Thank you. So, interestingly, speaking of utopia, Lady Carr, the Lady Chief Justice of England and Wales, recently called for the establishment of a London Dispute Resolution Committee to make recommendations on how best we can provide a holistic approach to international litigation, arbitration and mediation, which she said could mirror the considered approach taken in Singapore. So perhaps people are looking to Singapore for their utopia. I'll turn the same question over to Jan. What does a utopian dispute resolution system look like to you?
Sylvia, I'm stuck on the question you started with. What would make a potential disputant to an international contract about to be signed? Because that's where we are at the beginning of the process. What would make such a potential litigant in an international commercial context choose a particular court, now calling itself an international commercial court? I think it's fairly obvious. I would imagine what that court would look like. We all come from different environments. We have different skin colors, we have different cultures, we have different religions, we have different languages, even though we all try to speak English. I want to know if this court I'm going to be faced with looks like me, to any degree. I'm perhaps even more interested in knowing if that court is going to look like my opponent and not at all like me. And a lot of things flow from that. Let me take an example of another international commercial court which was just mentioned, which I didn't. Yet another variation. The French now have international commercial courts. So do the Dutch, quite similar. What is it? In what ways is it international? Do I see myself as somebody from far from France? Do I see myself in the faces of the judges in front of me? Well, the French call this court an international court because all it does is deal with international commercial cases. Fine. So it's specialized in international cases. That's good. They know something about international transactions. That's helpful, but national courts, other national courts, which aren't necessarily called international, can do that as well, but fine, that's something. Next, in France, in this court, you can speak English? I lived 30 years in France. I would never have believed, never have believed that the Republic of France issuing judgments in the name of the French Republic would allow people to present their cases in English. But that's what this court says you can do. I don't think it happens. I don't think it has ever happened so far. Lawyers who appear before the French court are allowed to speak English, but don't. I have not heard, I could be wrong, I don't think it has ever happened, because you want to win your case and you want the judges to understand you, and they're all French judges. So that's the last point. You're allowed to present in English, and it's not, I don't disparage it, because one of the things you can do is provide documents in English without translation. And that's not a problem. French judges know enough English. That's good. But you see, we haven't got all the way there. And that's what you have. A court which is all French, ultimately. So I think you see from that palette, we can imagine very easily what are the international commercial courts which will commend themselves to somebody who is really looking for neutrality and seeing myself somewhere on the court.
Well, it's good to hear that utopia is English-speaking, at least. Focusing on ADR now, Wayne, what role do you think mediation should play in utopia, and what role do you think it actually plays in the real world today?
Well, look, I'm a great fan of mediation, and I think it's a very important, it's been probably the most significant development in dispute resolution over the last 30 years, I think, has been the adoption of mediation in many domestic jurisdictions, including my own. I think it has an important role to play, and I think it fits in very well into the, if you like, the multifaceted choices that parties have when they're entering into their agreement. So, of course, traditionally parties have always been able to choose the substantive law of their agreement, but now they have a range of choices as to dispute resolution systems which they will adopt, and they can choose whether or not they want a compulsory facilitative process of dispute resolution before they go to an adjudicative process of dispute resolution if the facilitative process breaks down. Now, I think also, in addition to party autonomy, integrating mediation into the institutions that operate for adjudicative dispute resolution is very important indeed. So that the courts I sat on in Australia, mediation was compulsory. I don't know that that's practically feasible in the international courts, but one of the things I've been surprised about in my role as an international arbitrator is the infrequency of mediation in international arbitration, and as a consequence, the prevalence of last-minute settlements, because very often, first time the decision-making parties are in the same place at the same time is over the weekend before the commencement of the hearing, and that's when they settle the case, whereas millions of dollars could have been solved if they'd gone to mediation 6 months or 12 months earlier. So I think it behoves all elements of the new, if you like, multifaceted system of dispute resolution to focus specifically on mediation, to encourage mediation without necessarily mandating it, but to make it available. And I think that adds to the freedom of choice that people have under this new system. They can choose if they want facilitative dispute resolution, if they want adjudicative dispute resolution, and if so, whether they want arbitration, and if so, what institution they want, what hearing venue they want, what supervising court they want, by the choice of the seat. So all of these choices are available to parties, and I think in an international context, it will often be the case that there might be different answers to those different questions involving many different jurisdictions, so that the seat needn't be the same as the hearing and the arbitral institution needn't be in either. I think that adds confidence to international parties having if you like, a mix of jurisdictions involved in their dispute resolution, because they won't feel that they're constantly playing an away game against a party based in the dominant jurisdiction.
Christy, Singapore is known to be a thought leader in the field of mediation. What insights can you give us from your jurisdiction?
Thank you, Sylvia. So there is so much that I would like to share, but given the time limitations, I will focus on 3 points, and you can hear more from my Singapore colleagues in the panel discussions tomorrow if you wish. So first, I would say that the dispute resolution ecosystem as a whole must be supportive of mediation. And I will give 3 examples of this. The first is that the Singapore courts actually have the power to direct parties to conduct mediation in the course of the court case. That power is provided for under the rules of court. But of course, as judges, we tend to prefer to nudge parties down that route rather than to mandate it. Another example is how the SICC and the Singapore International Mediation Centre have collaborated together to come up with a lit model clause as well as protocol. And what this provides for is the option of mediation after the commencement of court proceedings. So if the parties opt for that, they can actually have a stay of court proceedings for up to 8 weeks or even more, pending mediation. And if that is successful, the option to record the settlement terms as a court order, and if unsuccessful, to resume the court proceedings. The SIAC, the Singapore International Arbitration Centre, and the SIMC, the Singapore International Mediation Centre, have also collaborated together to formulate a similar ARB-MED-ARB model clause as well as a protocol that works in a similar fashion. And I think what's interesting is that these protocols envisage the mediation taking place after the commencement of the dispute resolution proceedings, where arguably there is a better chance for the parties to reach settlement, both because they have a better understanding of the dispute, the contours of the dispute and the pain points at that latter stage, and also because they're not just checking the box of a tiered dispute resolution clause. Now, the second thing I would say is that efforts should be made to bolster the enforceability of settlement agreements. That might be another takeaway. And I give 2 examples of what the stakeholders in Singapore have been doing in this regard. So the government, of course, has ratified the Singapore Convention on Mediation. That's one. And as a second example, The SIMC has been, I would say rather creative in pursuing cross-border cooperation. So what they've recently done is to collaborate with the Shenzhen Court of International Arbitration to establish an SIMC, SCIA, the Shenzhen Court of International Arbitration, Med-Arb protocol. And that allows the recording of any settlement agreement resulting from a settlement in the Singapore International Mediation Center as an arbitral award in the Shenzhen Court of International Arbitration. So that's an example of creative cross-border collaboration. This is going to be useful for parties with commercial disputes in China or where the subject matter of the dispute is located in China. The third takeaway I would suggest is not to look at mediation one-dimensionally, but to consider alternative or appropriate dispute resolution more holistically. And here, if I could give another example of what the Singapore Mediation Center's latest offering is, it's what is called an Integrated Appropriate Dispute Resolution Framework, or INTEGRA for short. And what this does is to address dispute resolution options for complex commercial conflicts, such as construction projects that run for a really long time, and you could have disputes popping up along the way. The idea is you unbundle the disputes within this long-term project and you apply the most appropriate dispute resolution mechanism to each aspect of the dispute. And in that way, you downsize the conflict and only the most stubborn parts of the conflict end up in adversarial dispute resolution. And the way this can be done is through two mechanisms. One, a standing conflict avoidance board where you have neutrals appointed to this conflict avoidance board by the parties, and through the working relationship, it gives real-time advice on how disputes that pop up along the way can possibly be resolved. Or alternatively, have a conflict management consultant who is a neutral, who reviews the dispute and relationship between the parties and formulates a ADR plan that helps them to unbundle the disputes and tells them how a particular dispute could be resolved perhaps most expeditiously. And only when you need resort to courts, then you take that as the final step. And in this regard, you can designate the SICC under this protocol. So if I could sum up in terms of the takeaways from Singapore, first, your dispute resolution ecosystem as a whole must be supportive of mediation. Second, to constantly be creative about ways of bolstering enforceability of your settlement agreements. And third, to constantly be innovative and think of mediation, alternative dispute resolution very holistically, and not just mediation as a silo.
Thank you. A lot to learn from Singapore, I think. And I should add that Saudi Arabia is shaping up to be a regional leader in the field of mediation. It was a founding signatory of the Singapore Convention, as well as the fourth state to ratify it, and a draft mediation law is expected to come into force shortly. And I understand that as part of Vision 2030, the government has set a goal of mediating 25% of all commercial disputes. So turning now to our final topic before we take a few questions from the floor, and that's diversity. Let's recall that diversity has several aspects to it. There's professional diversity, which relates to the training and expertise of our decision makers, their legal qualifications, common law, civil law, their technical expertise, but also human diversity, which relates to diversity in their personal background, focusing on gender, ethnicity, age, and other such factors. We've heard today how the international courts do better than the conventional courts in professional diversity, and that's part of their draw, makes them more like international arbitrators than domestic judiciaries. But how are all of these systems doing at human diversity? And I'll ask the question first to Brigid.
It's really an important question, and let me step back and say why I think so in a first principles kind of way. You know, diverse panels in arbitration, like diverse panels of judges, make more thorough decisions, they make better informed decisions, they make more considered decisions. But diversity is also critical to growing public confidence in the process, not just the outcomes. Diverse decision makers grow confidence in the rule of law. That's especially true for parties from emerging markets. And I think it's hard to understate how important growing confidence in our public and private dispute resolution systems is right now, today. I can't think of a more important project. The rule of law is just a set of ideas, and they're not self-executing. It holds when the public has confidence in that set of ideas. So if we can grow public confidence by diversifying the set of people who make decisions, we should figure out every way we can do that. And here I think the courts have an advantage over the international arbitration community in one specific way, which is we know who sits on them, and we don't always know who sits on our international arbitration panels. And so to the extent we can bring more transparency to the conversation about who is sitting on, not who specifically, not the specific people. Obviously, privacy and confidentiality is an important selling point of an international arbitration process. But if we can be more transparent about the kinds of people, the diversity of people who are making decisions on the panels of the different international arbitration institutions, I believe we can grow public confidence in their decisions. So at the International Center for Dispute Resolution, the AAA's International Dispute Resolution business, 30% of appointed arbitrators were women in 2024, which is good, but could be better. I don't think that anybody would disagree that we have work to do. We need the senior statesmen and stateswomen to lead on this issue. We need more mentorship, and we need you to promote younger arbitrators and arbitrators from communities that have been underrepresented. Again, it's critical to growing public confidence.
And just to say, accountability is obviously key, and I'm pleased to say that since the ERA Pledge was founded, there's been a lot more publication of statistics of gender-based arbitrators. Also to note that in Vision 2030, Saudi's aim is to increase women's participation in the workforce to 30%, a key number. Now, I think it's time, with apologies to Bill, to open the floor to some Q&A. So I am taking questions from the audience. One over there. I don't know if that... Are you able to shout? We can hear you.
Test.
Martin was saying about the, that's a lot better, about the need or the encouragement rather than mandating of mediation by international commercial courts. Is there a more nuanced position? And should international commercial courts have the power to order mediation, thereby creating a discretionary power to require rather than a blanket requirement for mediation? I have in mind a particular case which occurred in England and Wales very recently, but that's really by the by. It's a matter of general principle. Should there be a discretionary power to order mediation? Thank you.
Well, I'm happy to take that on first. The DIFC Court does have such a power, and we've exercised it. We have a small claims tribunal, and we've exercised it to mandate that all cases in that tribunal, and there's 500 or so a year, have to go to mediation before they can go to a hearing. In the CFI, the Court of First Instance, we have the power to direct mediation, but it is seldom used because of international parties, time and cost, significant time and cost is involved. If the parties are reluctant to incur that, it's a bit difficult to force that upon them. But we are thinking about using that discretion more aggressively in the future. But I think it's better to have it as, where you've got international parties, it's better to have a discretion rather than a fixed rule.
So thank you very much for the question. And I think what you're getting at is that voluntary mediation has a better chance of success. So far as England and Wales is concerned, we are moving from a place where we've really taken that as the end point to a place where we're taking it as a starting point, because we're recognizing the increasing importance of mediation and trying to build it in.
Any other perspectives from the panel, or shall I ask for a new question? Perhaps a fresh question. Number 6.
Assalamu alaikum. I'm Dr. Amira Nasser. Thank you for the brilliant discussion. We all have noticed the fast growth of use of AI in the legal profession. I have also noticed so many sessions talking about that and how it's going to improve the work, okay? How it's going to improve the work, especially in the legal profession. However, this is expected to have impact on human employment, as we all know. Although we know for a fact it's not going to replace humans, however, it's going to have impact in their employment in the field. What measures you think will be taken or implemented to reduce human unemployment? Thank you very much.
Would anyone like to take that question?
I'm happy to. I think that this is one of the most important conversations around AI that every profession should be having, but ours in particular, because generative AI is such a good fit for a lot of the things that lawyers do, and also that judges and arbitrators do. But I completely agree that the specific contributions that humans make to that process are not replicable, and in fact might be, we might be able to have more time for those when we can automate the things that technology can do just as well or sometimes better. It doesn't get hungry, it doesn't get tired, it doesn't get cranky. You can de-bias a data set easier than you can de-bias a human. But unless the legal community starts having these conversations soon, other communities will have more say than we do in what the future looks like, not just for employment generally, but for what pieces of our process we think are important to be driven by humans today, tomorrow, 10 years from now, 30 years from now. So this is one of the reasons I hope we can start to have more and more conversations about what the transformation looks like, or should look like, or we want it to look like, and how we can make sure that's where we end up. So AI governance is absolutely critical, and any organization that doesn't yet have AI governance principles developed should start developing them. And that's a good first place to start in this conversation. But right now, I'm worried we need more people around this particular conversation table within the AI discussion.
Thank you, Brigitte. And on that insight, I will now wrap up this panel with big thanks to our distinguished speakers for such an interesting exchange.